So if you really want to see a screen, you might scoot over and get cozy with these people on the side.
And then we can harass the speaker.
Then you can harass the speaker better.
Because we know her. Only those who know her can harass her. Because she'll know we're kidding.
Welcome to KW, and also welcome to part 2 of the Landlord series that Angela Zajkowski created. We wanted to offer this series because we felt like it was really important to get out a lot of information that people don't often get, and so why not hear it from an expert? Angela oversees the day-to-day operations of the Vermont Landlords Association. She serves, I'll get closer to you.
Yes.
She serves on legislative study committees and participates in the legislative process through drafting potential legislation, testifying in legislative committees. Say that legislative word a lot. On issues impacting commercial and residential landlords. She began her work with the Vermont Landlords Association in September of 2003, and she's now the principal member of that association. And she's a frequent presenter of landlord, tenant law, and best management practices seminars for both attorneys as continuing legal education and private landlord and property managers, right off the website.
Everybody.
So I also want to just take a minute to thank our sponsor, Movement Mortgage, who provided some entries for us this afternoon. So feel free to help yourself. There's Michael right there from Movement Mortgage. And just this class we like to hold for 1 hour sharp. I know everybody's busy. Please turn off your cell phones. You can keep them on buzz. Please turn off your cell phones. If anybody needs a restroom, you can exit right here or that door, and they're right on the other side of this wall. So
Thank you, Sarah.
you're welcome.
And if anybody missed the first seminar
That's true.
on marijuana, I am recording these, and they are up on the Vermont Landlords Association YouTube channel. So if you missed it or wanted to listen to it again, the first one's out there, and this one will be up as soon as I can get it edited and out on the page.
What's one nugget from that first seminar that you would say?
You can say no.
Yeah. I don't know.
There it is.
There you go.
You can say no. And Angela, thank you.
Thank you, Sarah. Thank you, everybody, for being here today. So today's topic is termination notices. I've called this the landlord's admission ticket to court. I did give a version of this presentation on Friday to a room full of attorneys. So you guys are getting almost the same presentation that I give to attorneys about why these termination notices are so important. And why many times if you call my office and you give me a termination notice, I'm going to tell you, sorry, you got to send this again. Which is what nobody wants to hear. So if you don't want to be in that position, feel free to call me before you send the notice. Or email me a copy of what you're sending first, because this is probably your most important document when it comes to enforcing your lease and evicting tenants. So some of the things you're going to hear me talk about, I always refer to the statute. What am I talking about when I say the statute? This is the Residential Rental Agreement Act. So if you're used to working in statutes, we're talking about Title IX, Chapter 137. So this is the body of law that the legislature has laid out to govern the landlord-tenant relationship in the residential context. So this is where you find the warranty of habitability, the access statute, the retaliation statute, and all of the information, well, most of the information that you would need for sending a termination notice. How long they need to be, how it gets sent. When we're talking about an eviction process, we're also talking about Title 12. So Title 12 in our statutes is what governs court procedure. So it lays out everything you need to know about how sort of the court process works and the rules related to specific court actions. So there's a whole section in there that's related to just evictions. That's much broader than just residential evictions. So it covers unauthorized occupants, it covers mobile home parks, it covers commercial evictions, but it is where we get some of our information. We also have some HUD requirements. So particularly if you're renting to Section 8 tenants or tenants that receive a subsidy, when you're sending termination notices, you may have some different things that you have to do because of some HUD rules that are out there. So those are federal rules that also overlay the top of this. We have debt collection rules. So it's particularly important if it's an attorney sending a notice, if it's a property manager sending a notice. But we do have at least one opinion from the prior Vermont Attorney General that put some requirements on actual landlords sending termination notices about some debt collection language that they need to be putting into their notices. So this is starting to get very complicated very quickly. And then this is a piece that everybody gets stuck on, even lawyers. This last one is what will trip up even lawyers. So we have a whole body of case law that has shaped what needs to be in these notices, how they need to be sent, what this magic language is, particularly for non-payment of rent notices, that you're not even going to know. You could read the statute and you're going to miss stuff and have a notice that is not good. So this is a complicated part about this. There's lawyers that don't even know what these rules are. So why does this matter? Jurisdiction. So this is just a really fancy way of saying that if you don't have a good termination notice, the court says, we cannot hear your case. We have no legal authority, i.e. jurisdiction, to deal with your eviction if your notice isn't good. Termination notice is bad. The net result is your court case gets dismissed. It's really, I have not, and I say I gave this presentation in a room full of lawyers and nobody corrected me. I cannot think of any other civil case where one document is so important. In pretty much any other type of civil litigation, you can fix things after the fact. You can modify or amend your complaint, or, oh shoot, I forgot to attach that piece of paper. Oh, here it is. And everybody's like, great. In an eviction case, something's wrong or your notice isn't attached to your complaint, you gotta start all over again. That's why this is such a big deal. And again, reading the statute won't give you all the information. It'll give you a good start, but there's little pieces and tidbits that you'll never find in there because it's that case law and some of it's practice. And judges just have certain opinions about how this works. So notice, what are we talking about? This is actual notice is what we're talking about. So actual notice is defined in the statute. And this is what you're required to give your tenants when you're sending a termination notice. So the first thing is it means proving the tenant got the notice. The standard is not I mailed it. The standard is receipt. So how do you do that? Well, you can send things certified mail, return receipt requested. That's that little green card that people sign. When one of them actually gets signed and returned to my office, we're kind of like, whoa, wait, what happened here? 95% of the time, the certified does not get signed for. But why do we send certified? We send certified because it comes with tracking. So when I put my first class letter in the mail along with my certified and I send them the same day, I can use my certified letter to track my first class letter. So I have a little bit extra information from the court to say, look, my certified was accepted by the post office on this day and they attempted delivery on 2 days later. I think it's pretty safe to assume that the first class was also delivered the same time that the certified was attempted to be delivered. So it just provides you with an additional sort of layer there. Within the statute, there is what we refer to as a presumption. So we presume that when you put something in the mail, it gets received at the other end. We have a lot of faith in our postal service. So the statute presumes that 3 days after you put something in the mail, it's received by the other person. So why are that 3 days? Why is that important? Well, it's important when you're talking about putting a termination date in, right? Because the tenant needs to have a certain amount of time for any of these various reasons that we're going to talk about for sending a notice. And if you're short on time, your notice is no good. You can have the sheriff deliver your notice. My office regularly uses the sheriff for sending termination notices. In fact, we do all 3 of these ways. And then I get angry phone calls from tenants sometimes. I got this letter 3 times. I'm like, thank you for calling me. You just confirmed you received your notice. Right? Excellent. You can also hand deliver notices.
You do a selfie.
If you dare.
So when I say hand delivery is not, well, I slid it under the door. Hand delivery is not, I put it in the mailbox. Hand delivery is not, I shoved it into the storm door. Hand delivery, it is handing it from one person to another in their hand. Now, if you've sent it one of these other ways, is the sliding under the door or sticking in the mailbox okay? Yeah. But if you're going to solely hand deliver, you need to make sure you're handing it to another carbon-based life form on 2 legs that lives in that property. Because the easy decision for a judge is when the tenant says, well, I didn't get this notice. And you have no way to otherwise prove that they got it. What does a judge do? Well, tenant didn't get notice, you didn't comply with the statute, case is dismissed. Some other things to consider. Debt collection language. This is really important, particularly if it's for a property that you don't own. It's particularly important if you're an attorney. Particularly important if you're a realtor managing somebody else's property. Debt collection claims are not necessarily fatal to a termination notice. Right? So if you fail to put some debt collection language in, it doesn't mean necessarily the case is going to get dismissed. But if I send a non-payment of rent notice as an attorney and I don't tell the person that I'm attempting to collect a debt, that's personal liability and a claim that could come against me personally as an attorney. Same thing if you're a property manager and you're sending a notice for one of the properties that you manage. There was a law firm in New York State that got nailed for violating the Debt Collection Practices Act, and these are federal requirements. Vermont has its own version. It was a 6-figure claim against the lawyer personally. So it's not really something to mess around with, and can have personal consequences to the person who's sending the notice. This is one that trips up a lot of people. So if you have a tenant that's receiving a subsidy, Section 8, that's the main one where it would come into play, you have to send a copy of that termination notice to the housing authority at the same time you're sending it to the tenant. We have a whole line of cases that are developing at the trial court level where the judges have looked at the HUD regulations, and HUD regulations require you to notify the housing authority anytime you're considering the tenant to be in default or have an issue under the lease. And the courts have said you haven't completed and don't have a successful notice if you fail to notice the housing authority. I've had it go as far as a judge not issue me a default judgment in a case unless I provided an affidavit from the case manager at the housing authority confirming that she'd received a copy of the notice because it wasn't clear on the notice itself that it had been sent to the housing authority. So it's something that they're looking at, and cases are getting dismissed if it hasn't happened.
You have to use the same notification.
Yeah, I would send just an exact copy. You know, there's no requirement that you send it certified. I mean, certified definitely guarantees you know that somebody got it and it was there. I haven't run into that issue. It's more just the landlord didn't do it, didn't send it to the housing authority. They're usually pretty good, and you can call them up a day or two later and be like, hey, did you get this notice? And they can send you a date-stamped copy of it back. But if you're running into an issue with a case manager, it's probably not a bad idea. But there's no requirement that you do that, just that you have mailed them a copy. And then when you get to the court case, your notice has to be attached to the complaint. And so the complaint's the paperwork that you file with the court to start the eviction. If it's not, again, with any other type of civil case, you could just be like, oops, sorry, here it is. With this particular area of the law, if it's not attached at that time, a case is dismissed and you get to pay the court another $295 filing fee to refile and start again. So it's dicey for landlords. All right, so the fun stuff. What kind of termination notices are out there? Why can you evict your tenants? Well, the main one that we see a lot is non-payment of rent, right? That seems to be primarily the big issue. Tenant hasn't paid you what they're supposed to. You can send them an eviction notice for breach of lease. So this is breach of lease or breach of statute. So if you don't have a written lease, you can still use this type of notice. So this is for behavior stuff, right? So police are being called, you're disturbing the neighbors, you're not parking where you're supposed to be parking, you haven't paid me a security deposit, you haven't paid for these utilities you're supposed to, anything that's behavior related. You are growing marijuana plants in your unit, right? I would fall into this one. No cause. No cause is I don't have a reason, I don't have to have a reason, I just want you to leave. It's basically a non-renewal of the lease. This particular notice can only be used if your tenant's either month to month or it's coinciding with the end of a lease term. So if you do 12-month leases, you can't send a no cause notice like 2 months into the lease. You have to wait till that lease is coming due and then send the no cause termination notice. Yes?
Quick question on that.
Yeah.
Notice to give the tenant, if it's a no cause, 30 or 60, is it dependent on the length of time they've been in the
Correct.
unit as well?
Correct, and we're going to get into those
Okay.
details. Yep. So this is just sort of the broad overview, and then we're going to talk about each notice individually. But yes, no cause, the amount of notice depends on how long the tenant's lived there and whether or not there's a written lease. So for you realtors in the room, the last type of notice is sale of building. So this is a very special subset. And this one actually only applies if there's no written lease between the parties. So, yes.
If there's a lease but it doesn't have any clauses to talk about sale of the building, does that not apply?
Nope. Nope. So it would be a no cause notice, or whoever buys it is buying subject to that term lease. So sale of building is only if there's no written lease between the landlord and the tenant.
So that means month to month as well?
No written lease between the landlord and tenant. So what the term of that non-written lease is going to depend on how they pay rent. Do they pay rent monthly? Do they pay rent weekly? But you can, I mean, if it's a verbal lease and they're paying weekly, you're probably better off sending a no cause notice versus a sale of building notice. But I see a lot of sale of building notices when the property goes under contract in the middle of like a 12-month lease. And then people come to me and they're like, well, we want to get rid of this tenant. I'm like, well, you can't. Because this notice we're not going to be able to do anything with this. So it's a special subset with no written lease. All right, notices. This is stuff that's going to apply to all of these different notices. Anybody that's over 18 living in the building needs to be on the notice, regardless of whether they're actually listed on the lease or not. So we have some landlords that do a written lease with one adult in the unit. I don't know why they do that. I think maybe they think it's easier to manage. We'll talk about why that's not a good idea at the next seminar when we talk about leases. But anyone who's over 18 that's living there needs to be on the termination notice. The termination notice needs to have the rental address listed out in full. So it should be, 123 Main Street, Burlington, Vermont. Not just 123 Main Street. What town? We presume it's Vermont, but I've seen some weird stuff. So just always put the whole address in. Notice has to have a specific date of termination. October 15th, 2018. You cannot have a notice that says your tenancy will terminate 14 days from the date you receive this notice. Needs to have a specific date. Yeah. Got ahead of myself. Yes.
What about in the first one, you know that somebody over 18 is living there, but they've hidden it from you,
Yep.
but you know they're there.
Yep.
What do you do then?
So we would probably say, do Joe Smith and all others residing at the property? We'll send the sheriff out to serve that termination notice. The sheriff will find out who it is. Hopefully you have a written lease that says nobody else can live here, and then when we start the eviction, we treat that person as what's called an unauthorized occupant. So we do have a tool now to deal with those folks, but what happens sometimes is a landlord will rent to like 4 people, 4 adults, and they'll have a lease with one of them. They know the other 3 are there. It's been with their permission, and then they'll send the termination notice to just the one person that they have the lease with. It's got to be to all 4 of them, particularly if the landlord's known they're there and is fine with them being there. Yeah. All right, non-payment of rent. So this is a piece that is not in the statute and nobody loves to have in the notice. But if you're terminating somebody or sending them a notice for non-payment of rent, they always have the ability to fix it by paying. And the notice itself has to tell them that they have that right. This is the one that gets the landlords the most cranky. I send them a form notice and they're like, well, I'm just going to take out this line. I'm like, no, don't take anything out of the notice. The other piece is it has to be just rent. Rent is rent is rent. Rent does not include utility charges that they haven't paid, even if they're responsible for it under the lease. But it's not rent. Rent is not, they didn't pay me the security deposit, so I'm going to add that to what they owe me. It's not, well, I paid $1,200 to have this unit treated for bed bugs, so I'm just going to tack that onto their ledger. Nope. It's just the unpaid rent. I can generally tell when something else has been added in because I'll get a termination notice that says, tenant, you owe $1,247.32. And immediately I'm like, well, landlord, can you show me your ledger? Where does this number come from? One time, the number with that weird cents on it was actually correct because somebody had signed over a paycheck that had a weird amount, but only once has that happened. Generally, it's a utility charge or some other fee that's been included in. So just rent. Where does this get complicated? Well, if the tenant's been making like weird payments, like how do you apply those payments? Do you apply them to rent? Do you apply it to security deposit? Do you apply it to that utility bill that they haven't paid you? I don't have a good answer for you. I don't know. Because the courts are all over the place with how that gets handled. So generally, if you're tracking everything together, what I would do when I see that ledger is back out everything that's not rent that's been added to that ledger and then end up with a number. So yes, most payments you would apply first to rent. Do you have a question? Please feel free to ask questions throughout this. Totally
Under
fine.
utility charges, would that then exclude the cost of water, which by law you have to include in the rent?
Well, no, but I mean, if you're charging them one amount for rent, then that's the rent. But when I'm talking about utility charges, sometimes for whatever reasons, the water bill, if it's a single family home, is in your name. So you get the water bill and then you forward it to the tenants and they're supposed to pay it under the lease. If they don't pay it and you pay it, it's not unpaid rent, it's an unpaid utility charge. Right. But if you have a property where heat's included in the rent, then the rent is the rent. But we're talking about if they're separate accounts or they're separate payments or they're supposed to pay you separately for the utilities or they have the utilities turned off and they get turned back on in your name, those are the types of situations where that does not get included in what's owed in the non-payment notice.
So probably best practice just to have everything included.
That's what I was just thinking.
It really depends on how your building's set up. Guess who can turn the power off in the middle of the winter if they don't pay them for the power bill? Green Mountain Power can. You can't. You can't have the utility shut off. But the utility company has rules that they can follow to shut off for non-payment in the middle of the winter. It's totally building specific and business model specific. Some Some buildings, the utilities haven't been broken out, so it's not cost feasible for the landlord to do anything but have everything included. Some landlords go with a model that utilities are included because they think it makes it easier for the tenants or more, their property's more rentable, right? You pay once, this is the amount, everything's included. You know, some of it's a marketing strategy. Depends on who your market is and what your rental is. Needs that debt collection language. I tend to put them in all of my notices, but that's just because I don't have to deal with those other issues. So we don't have a 3 strikes rule on rent anymore. We used to have a statute in Title IX that said, tenant, if you're sent 3 termination notices in a 12-month period, you lose your ability to cure. That was great. Except over in Title 12, where court procedures handled, the statute over there said, tenant, you can pay for non-payment of rent at any time and save your tenancy. So realistically, we didn't actually have a 3 strikes rule, even though it was in the other statute. So how do we fix this? Well, we got rid of the 3 strikes because it wasn't working. So now if you file a court case against a tenant, they can cure that court case one time in 12 months. So everything's tied to the actual court eviction for losing your ability to cure. If you have a tenant that's a bad payer and you're on a 12-month lease, you could literally every month for that 12 months send them a non-payment of rent notice to which they cure. And you could keep doing that month after month after month. How do you fix that? When you're coming to the end of that 12-month lease, you send them a no-cause notice because you're tired of dealing with the late pay all the time.
How long do they have to cure?
For non-payment of rent,
Yeah.
14 days. So the minimum for a non-payment situation is 14-day notice. If you're mailing it, it's going to look more like an 18 to 20 to 21 day notice because you need to add in some time to allow for delivery.
So from the date of receipt.
From date of receipt. Yep. 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 All right. Breach of lease notice. This is our bad behavior notice. So, things to consider. These are the ugliest, messiest types of evictions. The breach of lease. We do them. We'll get tenants thrown out for bad behavior. But these are always the cases that take the longest. They have the most moving pieces, and they generally require other people coming to court to testify. So you generally need other residents in the building to come in to talk about whatever behavior is that's happening. You usually don't live in the building with the tenants, so you don't know.
Can they cure the problem? For example, if you send them a notice they got a pact,
Yep.
and they're not allowed, and then can they then get rid of their pact?
There's a pretty vigorous debate. I don't know. They actually don't know the answer to that question.
Oh.
There's no cure language anywhere in the statute. I think my experience with most landlords is they don't, if they send a notice about the pet and the pet goes away, they don't want to spend the money to find out. So most of the time landlords are like, great, the behavior is fixed, we're fine, everybody's going to move forward. So I haven't run across a landlord that's like, it was a default, I sent him a notice, I don't care if they got rid of the dog, we're going to court. I haven't found that person yet. So I don't know. Most of the time they don't cure, and then we're talking about what it looks like, but it's an interesting question, right? Because technically if you send a default letter, that's it, there is no cure, but nobody's litigated that one, at least that I'm aware of. So.
How about therapy pet? I know it's a little off what we're talking about.
Yeah.
If you're going to cover it later, that's fine. But if they say it's a therapy pet.
It's still, so that would be an exception to like a no pets policy. But you can still put parameters on how that pet behaves or how that assistance animal behaves. And the courts will back you up on it. I evicted a tenant out of a project-based Section 8 unit for having an assistance animal that was highly aggressive, disruptive, and was causing all kinds of problems within the project. we told the tenant, basically you're approved to have an assistance animal. You can't have that one because of all of these reasons. And the tenant pulled the, I'm not getting rid of this dog from my cold dead fingers sort of thing, and now has no housing because of it. So the courts will back it up, but you have to be able to show there was a problem.
Do we have to, as landlords, do we have to allow a therapy dog?
Yes.
But what about if it's a fake support dog license, because they can get them online?
So you have to do some due diligence, right? So if we're talking about emotional support animals, the standard is that the person has a disability, and if it's not obvious, then you can ask for confirmation that they have a disability. And so that usually is that note from the doctor. And that's enough to say, yep, I need this animal, and it's an animal. It's not necessarily a dog or cat. It could be a fish, snake, miniature pony, peacock maybe, we don't know. Definitely not on the airplane. Housing is a different story. And then it becomes a reasonable accommodation to your no pets policy. So they have the right to say, I need this. And then that animal is not considered a pet. It has a different legal status.
Does if you have a condo and an association has no pet,
Yeah. It's the same.
Does the therapy pet trump the association?
Yep. So it's a reasonable accommodation to the.
I hate to use trump, sorry.
Sorry, it's
Fair hazard.
the request for a reasonable accommodation will also apply to condo association bylaws that have no pets policies.
Can you ask a tenant for the letter from the doctor?
Mm-hmm.
And if it's an approved pet, are you within your legal rights to do that?
Mm-hmm. Yep. But the letter may not come from a doctor. It may come from a nurse practitioner. It may come from a therapist. It may come from a social worker. The legal standard is actually a person with knowledge about the person's disability.
Is there something that a higher power that can say this particular person needs to have this done? Is there a Vermont statute? Is there a law?
Well,
we have to get paperwork from.
There is no official paperwork, right? So one of the things that Susan was talking about is anybody in this room could go out, pay $75, and get a little certificate off of the internet that says, I'm a disabled dog, or I'm a disabled whatever. That does not meet the legal standard. There is no registry. There is no official certification paperwork for these animals. So if somebody comes in waving this thing I've downloaded off the internet, that you could say, no, that documentation does not work. That's perfectly fine.
Is that a state statute or is that
It's both federal and state. Yeah, so it's the bulk of it comes from the federal fair housing statute. We could probably do an all-day seminar on federal fair housing. My fair housing book is about this thick, and it's on this super thin paper. It's like thousands of pages.
It's on rice paper.
It's on rice paper. So it's a really complicated. There's lots of stuff going on federally. So, I get calls all the time, we got to do something about this. And I'm like, there's not much I can do here in Vermont because most of this information and most of the rules are coming from the federal level.
Is there a limit on the number of therapy pets you can have?
No.
Lack of chickens.
No, I
Chickens.
No, I know.
You have cats, and you said I gotta get a therapy dog. I said no, but obviously I wasn't allowed to say no.
We will not turn the camera around. We do not know who that was.
Just
Well, I had one who had a puppy who was going to be the therapy dog.
Well, so this is where it gets complicated, right? The requirements for bringing an animal with you to a grocery store, a restaurant, on an airplane, those rules are different. animals are supposed to be specially trained, can only be a dog or miniature pony, and have to be trained to do a specific task or function.
You say it can only be a dog or a miniature pony?
For coming into places
Where
of
did miniature pony get such special treatment?
They're very smart.
they're very smart, they're highly trainable, and people with certain types of disabilities are able to use them for mobility. Yep. So there's a whole different set of rules that are more strict that apply to places like restaurants, retail stores, hotels, things and the like. When we're talking about housing, it's emotional support. So it doesn't have to be specially trained. It doesn't have to do anything special. It just has to, most of the time it comes in the context that makes the person feel better. It makes them want to, I mean, it is the definition of a pet.
Right.
But we've given special legal status to this other thing. So not to get us too far off topic, but I will say, given all of this information, and we'll talk about this more in the lease section next month, is I've been raising the question with landlords, when you know that, maybe it's time to be re-reflecting on your no pets policies. Because if you allow pets, you can collect a security deposit if it's a pet. You don't run into these issues. I mean, you will have some legitimate assistance animals, requests for assistance animals, and then the deposit's waived. But if you have something, if you have a no pets policy, you have an animal come in on an assistance animal basis, you can't collect a deposit for that animal. And you know it's going to come in anyway. I personally think a huge number of emotional support animal requests are people's pets, that they have gone to their doctor and asked for a note. And what healthcare provider is not going to write a note saying, Sally needs her dog?
But if the pet starts being destructive to your property, you have the right.
You have the right to ask that dog, them to get rid of the dog or to evict the tenant. Absolutely.
So just real quick, what if you have no pets and everything, and your tenants come in, and halfway through the lease they decide they need a therapy animal?
Yep, it's fine.
Yep.
It's fine. They can make the request at any time.
And you have to honor it.
They could, that case I was talking about where we were evicting that tenant, she made the request for reasonable accommodation for that animal after we had already started the litigation. And we had to deal with the request, and we approved it. She legitimately needed something. So we said, we said, you're approved. We agree. We will grant you a reasonable accommodation to have an assistance animal. You cannot have this one, though. And the court agreed with us. So that request can come at any time. Right? Nothing makes you more cranky than to approve an application and you're signing the lease and they're like, oh, by the way, here's my assistance animal. Right? Did that happen to you? It's, yeah.
So in the case of somebody who has an animal.
Yep.
And it's, for example, a Chattahoola, which is a state dog of Louisiana, pit bull, bred to fight bears.
Yep.
And it voids your insurance. Then you would go back to you can have an animal, but not this one.
So first, I would request that your insurance company give that to you in writing.
I did.
And then I would also make sure that your insurance company knows that that it's a tenant making a reasonable accommodation request. And then what I've been told by the Human Rights Commission is that if your insurance company still says no, they want you to report your insurance company to the Human Rights Commission because they also are not supposed to be having a banned breeds list. They're supposed to evaluate on an animal-by-animal basis when it's a reasonable accommodation.
Well, if I can just add, I had my insurance company go out and get a policy coverage, but it was going to cost me $600 more a year.
Yep.
I offered it to the person who wanted to rent, and she didn't want to make the payment.
Yep.
And then she said, well, I'm too tired to go to fair housing. Well, but in any case, I didn't have to put up with it, but it happened.
You might have dodged a bullet because she was too tired. But we're seeing less and less insurance companies that have that banned breeds list because they've become the target, because they're supposed to also engage in this process of looking at the specific animal when it's a reasonable accommodation request.
So if they, if your insurance increases your rate, can you pass that along to someone?
That could potentially be a legitimate business reason for denying that emotional support animal. Potentially.
Say that again?
You have the ability for legitimate business reasons to say no to certain things. For a long time, the insurance piece was a good one. Like, oh, my insurance company says no. So then the insurance companies got sued. So now a lot of them are relaxing that request. They would probably have a hard time justifying that rate increase for an emotional support animal. I would push back on that, because that legal status still applies, all the way through. But that would be one of those ones we would want to have a conversation. Or you'd want to have a conversation with your attorney or whoever helps you with these things, because it's a lot more complicated than just like, yes, no, yes, no. So.
And what would taking a look at the specific animal entail?
History, vet records, have there been other complaints, where has it been licensed, have there been, complaints about aggressiveness, bite history, and things of that nature.
Doesn't that go back to what about on leased land? Because I just recently closed on 2 different properties for leased land that has a restriction, no, these dogs are not allowed in our park.
I think that's also going to be, if it's an emotional support animal, it's going to be an exception to that no pets policy.
And that's state owned.
Yep.
The leased land.
Yep.
So it still has to be, if it's a therapy animal, but they can still do so you can still have a restricted dog list.
Correct. Well, it gets complicated quickly, right? So they're saying, no, you can't. If it's a pit bull, we can't have it. I would push back and be like, no, it's a reasonable accommodation. You have to come evaluate the dog itself and not just on the breed. I get it with the breeds. I have 2 small kids. Do I have a dog that's a pit bull? No, I have a yellow lab. But I have friends that have pit bulls with small kids, and it's fun. So dogs are tough, and they're kind of like humans, right? You never know.
We're a lot stricter where it's shared. There's shared entrances in 6 units versus standalone in the country. We have a responsibility to the other tenants. So we're pretty strict around what type of animal we'll allow.
Yep. You may run into a problem if somebody makes a reasonable accommodation for an animal to come in. Here's what the Human Rights Commission tells me about allergies, right? Because everybody always wants to know. Well, I have this long-term tenant. They're deathly allergic to cats. And the new tenant is asking for a reasonable accommodation to have their assistant's cat come in. Human Rights Commission tells me reasonable accommodation requests trump allergies.
Wow.
Yep.
Wow.
Yep. Their point is that pet allergies, unlike say like some other allergies, peanut allergies or things of that nature, are not actually, they're uncomfortable for the person who has allergy, but they're not life-threatening. And there are ways to control those allergies. So that's...
If you have a lease, probably in the next course it's better to ask, but you have a lease with a no pets policy, the tenant has to come back to you to say, I want a reasonable accommodation, right?
Theoretically, yes. Theoretically, yes.
Okay.
Yes.
That's all I want.
Yeah, in theory, yes.
That's all I need to know.
Okay. All right.
They don't use that language.
Back, breach of lease. So some things to consider. Is whatever the behavior that's happening bad enough that a judge is going to say, yep, this person should lose their housing? So clearly having an aggressive dog is enough. Smoking in violation of a no smoking policy is enough. Pretty strong evidence that there's drug dealing going on is enough. Tenant's a big jerk. Probably not enough. Tenant yelled at me. probably not enough. Tenant punched his neighbor. Oh, definitely enough. So, and a bunch of little things could add up to be enough. So kind of, behavior ones can be tough. We want to see as many complaints as possible generally, and generally there are. It's generally not a one-off, right? If somebody's having behavior issues, it's not one little thing. It's a whole bunch of things. Does the behavior actually violate the lease? I was in court this past spring on a behavior breach of lease notice for the tenant's small children going out of a window onto a porch roof. There was also allegations that they were shooting BB guns at passing cars. We were in the middle of trial. You know what the judge said to me? Show me in your lease where it says that they can't be out on the porch roof. What? Do I need to have that in the lease? Is it not a violation of the fire code?
Or health and safety.
Or health and safety. Anyway, it did work out and the judge ultimately agreed with me, but this is kind of what we run into occasionally. I don't know, most normal people would say you shouldn't be out there. Particularly shouldn't be shooting BB guns out there, but you know. When you're putting together these breach of lease notices, you have to describe with enough specificity and detail what the behavior is and what the problem is. So if these are noise complaints, we want to see dates. We want to see very specific, not it was really loud. Music was being played past quiet hours on this date, this date, this date. Much specificity. We love to see police reports if there's police activity, because that'll give you a lot of detail about what's going on.
How about a front page?
Perfect.
On the Burlington Free Press of a partially burned down building displays.
Yep. There you go. There you go. So hopefully you have a clause in your lease that just says if the building burns down, we can terminate this lease and out you go. So we don't even have to do a 30-day breach of lease. We just pull the plug.
They're gone.
So we have a 30-day breach of lease notice. This is for probably 95% of the types of behaviors that we're dealing with. But we do have a 14-day breach of lease exemption or exception. And this is for behavior that basically endangers other tenants in the building. So this is for like tenant-on-tenant violence. This is for really extreme cases of behavior. I haven't convinced anybody yet to send a 14-day notice for removing smoke detectors, but I personally think that's a huge issue and can cause a lot of problems in a building, and it's a huge safety issue. But we use this one most frequently if there's been some sort of altercation between a couple of tenants. Yeah. So then we come to our no cause notices. So we have different standards for if there's a written lease or not.
Prove it. That's a standard.
And a lot of times people don't think they have a written lease if their original term lease has expired. So generally, if you have a lease for a term and that term runs out, that written lease still governs the relationship. It's just the term has changed, generally, sometimes. So the devils are kind of in the details. So if you're a realtor, if you're working with a client and you ask them, do you have a written lease? And they're like, no. The best follow-up question is, have you ever had anything in writing? Because I bet you a lot of the times the answer is going to be like, oh yeah. And that's important because the time frames are all based on whether you have something in writing or not with a tenant. So if you don't have a written lease and have never had a written lease, if the tenants lived there less than 2 years, it's a 60-day notice for no cause. Unless your property's in Burlington, and then it's a 90-day notice. Because Burlington has its own ordinance for some of these things.
If you've been there more than 1 year?
Less than 2 years. If the tenants live there more than 2 years and they don't have a written lease, it's a 90-day no cause notice. or 120 days in Burlington. There are different timeframes, and they're shorter, for weekly rentals and for rooms that a landlord has rented within their own personal residence. And I didn't put those in this presentation because we don't run into those a huge amount. But those timeframes are laid out in the statute, and if you run into one of those, just please call me. I'm happy to run through the details with you. They're anywhere from 7 days to 21 days, depending on what the circumstances are. So if you have a written lease with your tenant and they've lived there less than 2 years, it's a 30-day notice for no cause. And if they've lived there more than 2 years, it's a 60-day notice for no cause. There are no additional times for Burlington property. So if you have a written lease in Burlington, the state statute timeframes are going to apply. Burlington only added extra time in the situation where there's no written lease. So a lot of tenants, I think they have more time if they're in Burlington than the 30 days, and they're rudely disappointed, or shockingly disappointed, abruptly disappointed to find out that no, in fact, they only need to be given 30 days notice.
You purchased a property and inherited tenants, and you don't know exactly how long they've been living there. How do you calculate that?
If you're not sure, I'd always give them the longer notice. Because you can always give too much notice, but if you don't give enough notice, you're looking, it's a case dismissal situation and having to resend the new notice. So sometimes we get into weird situations where I even legally can't tell if we still have a written lease. Some of them are written very weirdly. And in those cases, sometimes I'll advise clients, listen, we should give them sort of the maximum time here and treat them as if they don't have a written lease, just to be on the safe side. It's giving them 30 extra days right now is not that big of a deal, but if we give them 60 days, file a court case, and 60 days down the road have a judge be like, nope, you should have given them 90, everybody's going to be really cranky. So sometimes you just will give them longer just in case. Cannot give them too much notice. Except maybe unless they forget that they need to move by a certain date.
Can you change the notice types? For example, we had sent out a no cause notice to a tenant, and then he gave us cause, and then we sent out a new one.
That's fine.
Shorter. Is that?
That's fine. It's fine. You can send as many different notices for different reasons at any time. What I would not recommend doing is sending a notice for non-payment of rent, and then the next month, if they don't pay again, send them a new notice for non-payment of rent, because that particular sequence would restart your notice time frame. But if you're sending them for different reasons, it's totally fine. All right, so we talked about the expired lease.
I hope this is in the same framework, but what about abandonment notices?
So I'm not talking about that today.
Okay.
That would be a good one for December. Stump the presenter. No. Oh. So abandoned property is I refer to it as the alien abduction statute, right? So your tenant just vanishes and you don't know where they are, generally. So I've run into it a couple times where it was true, like there was a half-cut tomato on a cutting board in the kitchen. We were like, what happened here? Ultimately, we found out that the tenant had been arrested, and that's what had happened. But we didn't find that out for a few months. But literally, it just looked like she got abducted by aliens. So there's an abandonment statute. The tenant owes rent. Somebody's not living in the unit full-time, and you've made reasonable attempts to try to track down where the tenant is. That's the one that landlords always stumble across. So reasonable attempts is you've called all of their numbers, you've called their employers, you've called their emergency contacts, you've reached out to anybody that would maybe know where they are. And if the answer is we don't know, then you have the right to legally take that unit back over, store their stuff, send them notice that you've done that. But it's always that third one. Because they start asking questions like, so did you call their emergency contact? No. their phone's been disconnected. Well, how else do you communicate with them? Do you communicate with them via email? Well, sometimes, so if you sent them an email. No, so it's, yeah. All right. So this is a fun one. Issues regularly raised by tenants' attorneys.
So I have a question on that. What if they clearly moved out, but
Yeah.
say they're still staying there and they're behind on rent?
They've moved out, but they're still staying there?
No, they're moved out, not staying there, but they're telling you through text, I'm still living there, when there's clearly no way possible.
I tend to be a little aggressive in that situation and just be like, they've moved. Right, I mean, and that's the point where you document, right? You go through, take pictures, like this is what it looked like here. Like everything's gone. You just change the locks and be done with it. Like,
So you don't have, to his question, if the tenant has left,
yeah,
you gotta just document that there's nobody living in the building?
Yeah.
And then just go ahead and rent it? You don't, because my problem is you got a lease for one period of time with them.
right.
Lease it to somebody else, their leases, they can come back in, right?
No, I mean,
No?
they've moved.
Okay.
They've moved.
Well, I agree with that.
And they're not communicating and they're not paying. I mean, that's,
What if they leave stuff? What if they leave?
It gets tricky where they leave stuff.
Like a person.
Yeah, and those are great. Yeah, right. You know what? We have a whole statute now to deal with the left behind people. Woo! We can talk about that in December. Those are great topics for our December one. Yeah, absolutely. All right, so these are things that tenant attorneys are looking for. And a lot of the counties now have these legal clinics where if you go in for a rent escrow hearing, which is part of the eviction process, they get free attorneys. They're there. I've trained some of them, so I know.
Can we get free attorneys?
No, sorry. No. All right, so these are things they're looking for, right? Does the notice say what the termination is for?
Oh, right.
Right? Is it clear in the notice if it's for non-payment of rent, breach of lease, no cause? Like these are all important things to have in. Did you have a specific date in the termination notice, and can you show the tenant got it? Is it long enough? Who authored the notice? So they're looking for, the debt collection notice language. If it's non-payment, they're looking for, do you tell the tenant they have the right to pay and stay? Is the amount only rent? Did it go to a housing authority? All these things that we went over, like why are we talking about this stuff? Well, because these guys are looking for this stuff. And they're looking for a reason to get your case dismissed, to buy their clients more time. Because ultimately that's what it is, right? It's just buying time. All right, so can you guys maybe see this? So this is a form notice that the association has put together and recommends. And this notice gets upheld in court all the time as long as you don't take out any of this language.
send it as a PDF.
Yep, save it as PDF or at Word. But, we have... No, it doesn't work on your screen. All right, so we have a spot for the date. So you want to make sure you have the date that you're sending the notice. Dear tenants, all the tenants' names go there. Your tenancy at, that's where the whole address goes. Addresses are hard. And particularly if E911 comes through and changes the address in the middle, it's kind of really complicated. But full address, including unit number, make sure you have the correct unit number. You put the wrong unit number in there, case will get thrown out. Terminated on with a specific date. Tenancy is being terminated for non-payment of rent as of the date of this letter. You owe blank and back rent. The important language, you can prevent the termination of your tenancy for non-payment rent if you pay all the rent that is owed. Right, so this is your ability to cure. Some legal language about we may be sending you other notices. Yes, Jay.
So with some of these, say, duplexes where it may be like, some people may say it's 101 Main Street, apartment A, apartment B, can you also have like AKAs, like upstairs unit, downstairs, just to try to drive it down to be, if it's different in like the land record, it says it's unit 1 and unit 2, but it's just to get rid of some of that.
I would provide as much detail as possible. I mean, generally, you're going to list out in your lease what the address and unit number is, hopefully. Sometimes the lease is incorrect too, which can cause problems. But it's possible. It could be 123 Main Street, apartment B, parens upstairs unit,
Yep.
just because that's what everybody calls it. But you really need sort of the legal address is the big one. Yep. This is our debt collection language here. So we have language in these for if the landlord's sending the notice that's compliant with the Vermont Attorney General rules, and then language for property managers or people who are not the owner of the property. And so that language should stay in this notice. And the idea was to remove the one that doesn't apply to you, but I see a lot of them where it's all still in there, and it's fine. It's fine. And we put a spot down here for if you're hand delivering the notice for the tenant to sign. So one thing I did not put in this presentation, and it should have been like its own slide, please make a photocopy of the notice that you're sending to the tenant. Don't just be like, oh, I got a copy on my computer, it's fine. No, make an actual copy of the actual notice that you put in that envelope or hand delivered to that tenant. Even if it means you have to delay a day. And why do I say this? I had a case once, this all stems back to that, I had a case once, where landlord brought me the notice, and I looked at it and everything was fine. And we get to court, the tenant comes in with a notice that the landlord had given him. The two notices did not actually match. Because the landlord didn't photocopy, they just filled them in by hand, and they put different termination dates in them. And the one that I was given had the proper amount of time. The one that was given to the tenant was 1 day short.
Oh, God. Okay.
So please just make a photocopy and keep for your records. You should be doing the same with your leases as well. So you have a rash of folks lately who are like, yeah, I had a written lease, but I can't find it. Just please scan it in, save it electronically, do whatever. These are really important documents if you come to a court, if you are in a court situation. And particularly with a notice, if you don't have a copy, you're going to have to resend it. So please, Kinko's, like where, it doesn't matter, just get that copy and get the exact copy. All right, so this is all the fun stuff. Your notice is good for 60 days from the termination date. So that means you need to make a decision about whether you're going to evict that tenant or not within 60 days of that termination date. Otherwise, you got to send a new notice. Again, all persons over the age of 18 need to be named in the notice and in the complaint. We need a copy of your lease if we're going to go to court. It's something that has to, again, be attached to the court paperwork. There's a process for where the court can order tenants to pay rent into court while an eviction is pending. So this is this rent escrow process. It works pretty well. If people just don't have the money or just aren't paying, that's a good and pretty quick way to get them out. And I say pretty quick, court time frames are a lot different than our normal day-to-day time frames. So when I say pretty quick, I mean a couple of months, which is really fast for court process. So we have a different time frame sense in court. A big one is the property code compliant. Have the tenants complain to you about anything? If they have, it's a good time to schedule an inspection and go over and take a look and see what's going on, because they'll tell you what we hear when we get to court. I complained about X, Y, and Z, and the landlord's done nothing. Maybe they haven't bothered to tell you those things and we're hearing them for the first time in court, but if you've heard any rumblings about something needs to be fixed or you need to look at it, before you send a notice is a good time to go take a look. And on the heels of that, if your tenant's reported you to an inspector and you've received some sort of inspection report, we are not sending no-cause notices within 90 days of having that kind of complaint. It's considered retaliatory under the law. You can still send non-payment of rent notices, but please call someone like myself or your attorney first before you do it, so we can talk through and strategize on when a good time is. I can tell you with certainty that handing someone a non-payment notice 2 hours after they've made a complaint about some problem in the property is going to be deemed retaliatory by the court. So you still have the ability to send the non-payment notice, but we might need to wait a couple of weeks before we do that if the tenant's just complained. So here's my contact information if you have further questions. Yes, Sarah.
Tell us about the Landlord Association and membership.
Yes. How many of you are familiar with the association? We have a lot. I was going to say, I still have a lot of familiar faces in the room. But for those of you who aren't familiar, we are a private membership-based organization. We're essentially a trade association for landlords in the state of Vermont. So we rely on our members for support. Membership's $250 a year. And with that, we do things like the seminars, we do trainings, we provide all of these forms, leases, rental applications, termination notices, newsletters when I can get my act together. Did everybody get the one that went out last week? Yeah, finally! And a big component of what we do is lobbying and spending a lot of time down in Montpelier. These days, occasionally we're able to get changes done, but more importantly what we're doing is we're trying to keep things from getting worse down in Montpelier. Some of the rules that are proposed every year stays down. So.
Okay. I was wondering what your take is on this. An attorney once told me that all these rules have been put in place to avoid having people becoming homeless.
I think actually, and I did a presentation not too long ago on this. If you track all of the really big Vermont Supreme Court cases that have to do with landlord-tenant law, on the heels of those really big cases, we see statutory changes to the act. And it's more driven by case law and, frankly, landlords not doing what they're supposed to in pretty egregious situations. So our habitability statute came on the heels of a couple of court cases where tenants were living with no heat, no running water, sewage was backing up into the unit, there was leaky roof, and the landlord was just like, I'm not fixing it. So now we have a habitability statute that says, landlord, if you receive notice, you have to fix it. So we see the same thing with the retaliation statute and the illegal eviction statute. Landlords used to take front doors off of buildings to get tenants to move. So now we have a statute that says you can't do that. So, you know, it's fine to, you know, complain that the rules are very tenant focused, but most of them have come because landlords weren't doing what they were supposed to. So.
Drawing here? Is this what this is?
Yeah, it's a drawing.
Why don't you tell me?
So I brought